In this podcast, we'll be talking about the application of the postal acceptance rule. In Household Fire and Carriage, Kendrick was the agent of the plaintiff company offering shares. The defendant offered to purchase a share, and the offer had wrongly stated that £5 had been paid to the plaintiff's bank. The plaintiff sent a letter of acceptance to the defendant. The defendant never received the letter. The plaintiff allocated the shares to the defendant, mistakenly believed the payment had been received, and the case also talks about dividends that were declared on the shares. This is irrelevant to our analysis. Eventually, the plaintiff became bankrupt, and the plaintiff's liquidator sued the defendant for £5, and the defendant claimed that he is not a shareholder. The issue was, when is the contract complete? The court here found that the contract is complete and binding on the transmission of the notice of acceptance through the post. The fact that acceptance had been lost is irrelevant. And the reasons were that although this view causes hardship and inconvenience sometimes, it is the offeror who should bear the risk because the offeror controls the process. The offeror is the one who determines the type of communication for acceptance. The offeror can make inquiries of the person to whom the offer was addressed if the offeror does not receive a response. And if the contract isn't fully concluded until acceptance reaches the offeror, there are bad results, which opens the door to fraud and delay in commercial transactions. The offeree would never be entirely safe in acting upon his acceptance until he receives notice that acceptance reached its destination. There was a dissent here, which agrees with the postal rule, which is acceptance is effective when mailed, but questions the scope of the rule. The dissent had a problem with applying the postal rule as if acceptance was lost in the mail. Dissent said that there was no agreement form if the letter of acceptance is never received, and to say there's a contract is hard on the offeror, who may have assumed his offer was not accepted. The dissent basically said it's arbitrary to relieve the offeree of the loss and cast it on the offeror. The takeaway in this case is simply that the offeror can control the allocation of the risk, so it is preferable to protect the reasonable expectations of the offeree. In the next case, Hollowell Securities. In Hollowell Securities, the option for the purchase of real estate provided that the option, quote, shall be exercisable by notice in writing to the intended seller within a particular time period. The plaintiff posted notice to exercise the option, but it was lost in the mail, and the plaintiff had told the defendant that written notice was posted soon after. The issue here was, what is the scope of the postal rule, or when is the postal rule inapplicable? The ratio is that the postal rule does not apply in all cases where the party makes the offer where he expects the post to be used as a means of accepting it. Rather, it will not apply where the express terms of the offer specify that the acceptance must reach the offeror. It won't operate if its application would produce manifest inconvenience and absurdity. And the reasons here were that the requirement of notice in writing to the offeror impliedly required actual receipt by the offeror. The rule doesn't apply if the negotiating parties cannot have intended there would be a binding agreement until the party accepting had actually communicated the acceptance to the other. If you read the literature, you'll find that there is no general principle emerging in the cases after Hollowell Securities. However, it would be prudent of an offeror who wishes to avoid the application of the postal acceptance rule would stipulate that the offeree's acceptance will be effective only upon receipt. So using any medium for the transmission of acceptance has to be one that is reasonably expected by the offeror. The offeror, for example, who faxes over an offer to the offeree, probably does not expect that the acceptance will be sent back by mail. Here, the application of the postal rule would create a risk that the offeror would be caught by surprise if the offeree were able to claim that the contract was made when the letter of acceptance were put in the mail. It's really important to recognize that the postal rule only applies to acceptance of offers. An offer and a revocation of an offer, that is only effective when and where it is communicated by the offeror to the offeree. A rejection of the offer or a counteroffer is effective only when and where it is received by the offeror. Now, a problem has arisen with instantaneous communications when parties are at a distance. So way back when these postal rules were developed, people communicated without instant forms of communication. But as technology has progressed, we've had problems developing as to which law to apply. The development of the phone did not affect this because the parties could talk, and the offeree is able to accept without doubting whether the offeror attempted to revoke the offer before he received acceptance. So he applied the general rule to phone communications. It's the same rule as when parties are in each other's presence. But more recently, we have other types of communication, other types of instantaneous communication, which causes problems. Is faxed acceptance made at the time of sending or arrival? Now, many of you probably have never seen a fax or used it, but it is still applicable. In fact, the Government of Canada uses it when communicating through the CRA. So, is faxed acceptance made at the time of sending or arrival? Disputes regarding the location of the contract formation if the parties are in different places. How about if the email is delayed or sitting on a mail server, but it is inaccessible by the person receiving it? So as technology progresses, there are still problems as to when exactly the communication happens if the people are not within an area where they can communicate instantaneously. And that all leads to these questions of, do we use the general rule or the postal rule? Assume the offeree is in New York, the offeror is in Vancouver. The offeree emails the offeror in Vancouver. Well, the general rule will say that the place of contract formation is Vancouver. The postal rule will say that it is effective when it's sent from New York. So which one? On one hand, we have essentially instantaneous communications. On the other hand, emails are subject to the same problems that can arise with mail. There can be delay or loss. There can be a person who isn't there to receive them. Now, so far, the courts have held that the general rule is applicable to these instantaneous forms of communication. So in cases where the means of communication of acceptance are virtually instantaneous, the phone, the fax, the internet, the normal rule, which is that acceptance must be communicated to the offeror for the contract to arise, will apply. You see this in Brinkebon and Stagg, where the appellant English buyers want to sue an Austrian company, the sellers, and the decision is on a preliminary procedural point where the defendant is in Vienna, who telexed an offer to the plaintiff in London, which is for the sale of steel. The plaintiff in London telexed acceptance to the defendant in Vienna. The plaintiff in London opened a letter of credit, which is a method of payment, in Switzerland, and the plaintiff would be able to sue in England if the contract was formed in England. The issue was, when and where is the contract formed? When an instantaneous form of communication other than the telephone is used, which rule should be applied in that case? And the court said the communication should be classified as instantaneous where the condition of simultaneity is met and where it appears to be within the mutual intention of the parties, which means the contract is formed when and where the acceptance is communicated to the offeror, meaning the postal acceptance rule would not apply. However, the court also said that no universal rule can cover all such cases, and cases must be resolved by a reference to the parties' intentions, sound business practices, and a consideration as to where the risk should lie. The reasons here were that if you have an instantaneous form of communication, such as the telephone, the acceptance is effective when and where it's received. A non-instantaneous form of communication, such as mail, acceptance is effective when and where it is sent. The telex was classified as instantaneous communication, so acceptance is effective when and where it is received, which is in Austria, which meant that the buyer is unable to sue in England. Now, presumably, the same rules apply to fax and emails. Lord Wilberforce here said that if it's not broken, don't fix it. The decision in Torres 1955, which was cited in Brinkebon, did not cause adverse comment or any difficulty with business people. However, unlike the situation where the parties are speaking to each other in person or on the phone, the use of a telex, or now the fax, creates risks which have to be allocated. So while the instantaneous rule should be applied in the circumstances of the case, Lord Wilberforce did note that no universal rule can cover all cases. Lord Fraser said that the reason for treating telex communication under the general rule, which is acceptance is effective when and where received, is that once the message is received on the offeror's telex machine, you can treat it as delivered because he's responsible for arranging for prompt handling of messages received in his office. A person who tries to send a message by telex can tell if the message has not been received by the other party, whereas the offeror will not know about unsuccessful attempts to send acceptance to him. Therefore, the offeree is in a better position to ensure the message is received. So he should bear the risk. Now, what can we take from this case? In instantaneous communications, the traditional rule will normally apply. Given Lord Fraser's comment on the fact that the offeror should bear the risk, and comment that this is not being a universal rule, well, if there's a problem with the form of communication that makes it impossible for the offeror to receive that acceptance, as in it's broken or it's out of paper, and the problem is a result of the offeror, then maybe we need to reconsider the principle and apply the postal rule. But when we're thinking about that and about other forms of communication, so email or the problems that can arise from that, so for example, the email server is down, the important question again is the need to allocate the risk of loss in a commercially reasonable way. We need to take into account the expectations of the parties and their ability to control the risk. In these situations, as when the fax goes astray, we need to keep the words of Lord Wilberforce in mind. No universal rule can cover all such cases. They must be resolved by reference to the intention of the parties, by sound business practice, and in some cases by a judgment where the risks should lie.